222, State of Ohio versus Sarah Tomer. You're Sarah Tomer. And Mr. Tomer is appearing self-represented. On behalf of the state is Assistant Prosecutor King. The defendant has filed a request for sealing. Actually, the court said this because the defendant completed successfully the intervention lieu program, and the matter was dismissed. Looks like pleaded guilty was in February 14. Entry was filed on March the 31st. And the court did order a report from probation. And according to that, the only thing that's been on her record since then is the traffic offenses. So a left to center actually is the only thing since that time. So based on that, Ms. Tomer, the court will order that your record be sealed. Have you paid the $50 fee?
Yes.
Okay. All right. So we will prepare an entry that'll get filed to the clerk. It'll probably be tomorrow. And then it'll be sent out to all the agencies. It takes usually around 30 days to get it removed from the various records. One thing the sealing does not do is seal anything in third-party, non-governmental hands. So, like if there's been a background check, for a job application, people have that information. They're not required to destroy it. It's personal, private. But for that reason, you should make sure you keep copies of your entry, so that if something like that should surface, if you apply for a job and they use the same company that did a background search before, or your insurance. I know in insurance now, a lot of times they run record checks, and they may keep those in the file, and it may show up. So if there's a question arises, you can show them a copy of that, or give them a copy. Don't give them the copy that's file stamped with a seal on it, because that's the only one you'll get. If you do, you'd have to go back and get another one. So like I said, we'll take care of that, and hopefully within the next 30 days or so, all that will be removed from the public record. Okay? Thank you.
Thank you.
All right. Okay, this is case number 22 CR 124, State of Ohio versus Brent Allen Reinhardt. Mr. Reinhardt is appearing by video from the institution. His attorney is William Armentrout, who is present in the courtroom, and also present for the state of Ohio is Assistant Prosecutor King. Defendant was sentenced on July the 6th of 2022 on 2 counts of aggravated trafficking and methamphetamine third-degree felonies to a term of 48 months. He has filed his request for judicial release. The court ordered a report to be provided, which I have received from the probation department. Now, Mr. Armentrout, anything that you would like to say regarding the motion?
Only what's contained in the original plea agreement, which I believe the state was not opposed to this being granted, Your Honor, and also I believe Mr. Reinhardt filed a motion pro se, and there was some a letter in there about some of his what he's accomplished while he's been incarcerated. We'd ask the court to consider releasing him.
Mr. Reinhardt, anything you would like to say in support of your motion?
I decided when I came in here not to waste my time, and I've completed several programs. I've been attending AA and NA, and I also graduated from an end-of-work class learning food service and managerial skills so I can have employment when I get out. I just would like y'all, the court, to please consider my judicial release. Thank you.
All right. Well, I did also receive confirmation that STAR CBCF does have a bed available for treatment, and so it's the order of the court that the motion for judicial release be granted. It'll be effective March the 14th. And the conditions of that, well, you'll be held until the 14th, and then you'll be released to the Highland County Sheriff at that time. They'll bring you here to the jail. You'll be held for 1 day until you are transported to STAR on March the 15th. Now, the conditions of your community control are, first of all, that you're to successfully complete the STAR program, and that is an absolute 100% requirement, and if you fail to complete it for any reason other than a medical condition that's not your own fault, such as smashing your hand against a brick wall or drinking lye or something, poisoning yourself. Other than that, you must 100% complete it. Now, the additional conditions are that you're to obey all laws of all jurisdictions and conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be honest in all answers that you give to questions they may ask you regarding your conditions. You're to obey all laws of all jurisdictions. You'll be on community control for 3 years. You must report when and as directed. You must keep your supervising officer informed of your residence and place of employment at all times. You may not change either without prior permission. You're not permitted to leave the state of Ohio without prior written permission. You may not enter upon the grounds of any correctional facility once you're released from STAR, or communicate with anyone as an inmate in any of those facilities without prior written permission. You're not permitted under federal and state law to possess, own, use, or have under control any kind of a firearm, ammunition, dangerous ordinance. If you do, that's a federal and or state felony subject to youth prosecution. You're not permitted to have any of those while under community control, nor any other weapons. You're not to purchase, possess, use, or have under control an alcoholic beverage, nor be plate or any other controlled substance, drug abuse, or any instrument, device, or thing may be used to administer those, prepare them for administration unless you have a prior written lawful prescription, a copy of which you must provide your supervising officer within 24 hours of receipt. You're not to be present in places where alcoholic beverages are being sold or consumed, even if it's otherwise lawful. Not to associate with anyone who's a co-defendant in this case, or any person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions. You may not marry or establish cohabitation in a common law marriage type relationship with another without prior written permission. must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. Must provide your supervising officer financial information records so your ability to pay restitution, child support, fines, or costs can be reviewed. If you're referred for an evaluation or assessment for any further treatment, therapy, counseling, training, educational programming beyond that ordered by the court, then you are to submit to that. And if there's a recommendation that you undergo additional programming, then you must enroll in and successfully complete that. You pay the court costs and make arrangements to do that with the clerk. You'll do 400 hours community service rate of 20 hours per week for 20 consecutive weeks unless you are employed at least 20 hours a week, full-time student, you have documentation by a physician or prior disability finding that you're unable to do that. There's also a restitution here is $220, is that what it was?
The check, Your Honor?
Yeah, $220 to the task force. And pay that through the Highland County Victim Witness Program and any service fees that are charged for that service. And as I said, you're to successfully complete the STAR program and aftercare. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property place that's under your control or where you're found at any time by any officer of the probation department. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file written notice of that with the court. You'll receive a copy. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that attorney or that hearing is that you have failed to comply, then the court can revoke your community control and return you to prison to complete the rest of your sentence. All right, do you have any questions, Mr. Reinhardt?
No, sir, thank you.
All right, so you'll be picked up on March 14th by the Sheriff Department. Thank you.
Thank you very much.
#21 CR 86, State of Ohio versus Dustin L. Swords, and you're Dustin L. Swords?
Yes, sir.
All right, Mr. Swords was convicted of aggravated trafficking in methamphetamine, a third-degree felony, and was sentenced to a term of 24 months on March the 1st, 2022. Mr. Swords has filed an application or request, motion I should say, for judicial release. He's filed that on his own, so he is self-represented and is appearing by video from the institution. Representing the state is Assistant Prosecuting Attorney Adam King. All right, Mr. Swords, you want to address the court and to give me the reasons why you feel that you should receive judicial release?
Well, sir, since being incarcerated, I've took it upon myself to, I'm enrolling GD classes. I go to NA and AA. It's inmate ran. Since I've never been away from my kids, my family, no longer than 60, 70 days at a time, and being in here for a little over a year now, you know, I've realized I took a lot of things for granted when I was home. You know, being away from my kids and my mother, you know, it's not a feeling I like very well at all. You know, and I mean, I know what I've done, it was wrong. You know, I fully accept, you know, responsibility for that. And, I'm not doing it no more, that's for sure. I've definitely learned my lesson from it. You know, just from being my family alone. I know my family needs me, my kids more than anybody. And I mean, that's what's got me going, you know, fighting the most. You know, and I plan to, you know, further my recovery once I get home.
Okay, anything else you'd like to say?
No, sir.
All right, Mr. King, on behalf of the state, do you have anything?
Just showing the state is opposed to the defendant's motion. The reasons are outlined in the memorandum that was filed on January 23rd. I would just note that back when this case was pending, it had to be put on the inactive docket for approximately 4 months due to the defendant's failure to appear and a KPS being issued. He didn't turn himself in. We had to go find him. It took about 4 months. And I would also note that he has already been to STAR. He's previously been on community control out of Adams County. That was in 2019. He was placed on 2 years of community control. And the offense in this case was committed on, checking the date here, September 3rd of 2020, which would have actually been while he was on community control out of Adams County. So based on that, the state is opposed to the motion, Your Honor.
Well, Mr. Swords, the prosecutor raises a good point, is that you've previously been to STAR and completed it, and then violated your community control and had that revoked. That was for an escape charge in 2019 out of Adams County. And you did fail to appear in this case, and it was several months before you were located. So what's your response to that?
Well, sir, I was on drugs. You know, that played the biggest role in me not appearing in court or not turning myself in. And I mean, I've been clean for over a year now, and you know, I'm thinking completely different than what I was then.
Well, Mr. Swords, I'll tell you what I'm going to do. I'm going to give you this chance, but it's going to be very strict. I'm going to grant you judicial release, effective March the 14th, a week from today. We release to the Sheriff's Department at that time. You'll be held in jail until you're conveyed to STAR on March the 15th. They have accepted you into the program even though you've been there once. You're required to successfully complete that program. There's no ifs, ands, or buts about that. You have to do 100% completion unless you get terminated for a legitimate medical issue that is not your fault, provided any pre-existing medical conditions were divulged. You'll be under supervision of the probation department for a period of 3 years. You'll be required to comply with all federal, state, and local laws and conduct yourself in a law-abiding manner at all times. You must be truthful in all statements you make to the probation department regarding your conditions. You must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You must report when and as directed. May not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility once you're released from STAR, unless you have written permission from your probation department officer. You're not to purchase, possess, own, use, or have under your control any kind of a firearm, ammunition, dangerous ordinance, or weapon of any type. And again, if you do any of those things, those could be subject you to a prosecution under both federal and state law. You may not purchase, possess, use, or have under your control any alcoholic beverage, any type of controlled substance, drug abuse, any instrument, device, or thing may be used to administer drugs, prepare them for administration. Unless you have a lawful prescription, you must provide a copy of that within 24 hours of receipt. You're not to be present in places where alcoholic beverages are sold or being consumed, even if it is otherwise lawful. You're not permitted to associate with anyone who's a co-defendant in this case, or any other person that has a criminal record, a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a violation of these conditions. You may not marry or establish cohabitation or common law marriage type relationship with another person without written permission. Must report any contact with law enforcement or any arrest, citation, or conviction within the next business day after that occurs. Must provide supervising officer financial information so your records to pay, your ability to pay any support, restitution, fines, or costs can be reviewed. If you are referred for an evaluation or assessment for any further programming or treatment beyond that ordered by the court by probation, you'll submit to that. And if any programming is recommended, you're to enroll in and successfully complete that. You're to pay the court cost of this action within a reasonable time and make payment arrangements to do that. You'll be required to do community service in 400 hours at 20 hours per week for 20 weeks once you're released from CBCF, unless you are working at least 20 hours a week, you're a full-time student, or you have documentation from physician or prior disability finding you're physically unable to perform those services. You're to make $150 restitution to the Highland County Task Force, and you'll make that through the Highland County Victim Witness Office, and pay any service fees charged for that. You're to successfully complete STAR and aftercare as recommended. Now, I'm also going to have you refer to the drug court docket so you can meet with those folks while they're at STAR and determine if that's something you would like to apply to be involved in. I don't order people into it, but I do accept applications. It's a very intensive program that's designed to help you rebuild your life, not just stay out of prison. So they'll interview. It's up to you if you want to refer, if you want to apply for that. But if you do, then the court would certainly look at that. Now, in the event that you, by being placed on community control and being released from prison, you're deemed to have consented to a search without a warrant of your person, vehicles owned by you or used by you, or any other property or place where you're found or under your control at any time, any officer of the probation department. All right. Do you have any questions, Mr. Swords?
No, not really.
Okay. Well, you'll be released on the 14th until, and then held until the 15th in the local jail when you'll be transported to STAR. All right. Thank you. And that's it for the DRC.
that. Press Alt-A.
All right, are you Leona Reinhardt appearing there from the jail? Okay, you're muted there, officer. You'll need to click the button down in the left-hand corner on the red of
Yes.
the button. There
Yes.
you go.
Yes, sir.
All right, thank you.
Is that better now?
Yeah, you're perfect.
Okay,
Yeah.
okay, thank
Could
you.
you, I don't know if she could either move a little closer to the computer so we can get a better view there. All right, thank you. All right. Yeah, I had 2 videos from the institution and we were having technical difficulties, so I didn't log in to Zoom. So I apologize for the delay getting you folks up and on the record. This case number 22 CR 125, State of Ohio versus Leona Reinhardt. This hearing is being conducted by Zoom. Ms. Reinhardt's attorney is Dennis Kirk, and he's appearing from his office, and representing the state is Prosecuting Attorney Collins from her office. The defendant was placed on community control in this case for aggravated trafficking in methamphetamine, a third-degree felony, on August the 4th of 2022. The court received notification of alleged violations of those conditions on February the 22nd and notified Ms. Reinhardt of the allegations, and then set the matter for hearing today, and appointed Mr. Kirk to represent her. Now, Mr. Kirk, did you have an opportunity to review these allegations with the defendant?
I did, Your Honor.
All right. And
I did give her, advise her of her right to a hearing. She does wish to waive that hearing and admit to the violations.
okay. Now, before I go any further, are you and your client both in agreement that this matter can be held by Zoom remotely rather than being held in person in the courtroom?
Yes, Your Honor.
You're all right with that, Ms. Reinhardt?
Yes, sir.
All right. So, Ms. Reinhardt, just to review, on February 22nd, a notification filed alleged that you violated Rule 2, that you failed to report since January 19, 2022. I believe that should say 2023.
That's correct. I tried to amend it, but I don't think you could hear me or something. I don't know.
No, I didn't hear you.
It should be 23.
Had to be a technical issue, because if you talk, I can hear you. So,
No, I think you just are ignoring.
I would never do that. Yeah. All right.
It should be 23.
All right. I'll make that notation on it right now. All right. Rule 7 alleges that on or before December 20, 2022, you consumed meth and amphetamines, and on or before January 19, 23, you consumed meth, amphetamines, kratom, and buprenorphine. Rule 13 alleges that on January 19, you were referred to Lynn Goff by the probation department, failed to show, as directed on the 23rd. You then put yourself in treatment on February 1 at the counseling center, and then on February 1, that was done without the knowledge of the probation, but you did that on February 1, and then without their knowledge, you left after they did receive this on later, but they were informed that you had left services against the advice on February 15th. That's when they received the notice. And then Rule 19A is that you have failed to complete substance abuse treatment as directed. This was signed by Officer Parnes on February 22nd, 2023, and there's a signature, looks like your signature as well on that date. And then you also made a comment that you didn't agree with all this stuff. It's only half the story. Assume that's your writing, and your signature below that, it looks similar to the signature of the defendant. Now, you understand those allegations against you, Ms. Reinhardt?
Yes, sir.
And you understand that you have a right to a hearing on this in which the state will have to prove these allegations. You'll be entitled to have your attorney ask questions, cross-examine the witnesses to try to bring out evidence to help you you'll have the right to testify and present evidence in your own defense. Now, in the event that you fail or that you are found to have violated these conditions, whether you admit to that or whether there's a hearing, one of three things can happen. I can continue on community control under the same conditions that were previously ordered. I can continue on community control with additional conditions that I think are appropriate, including extending your probation to up to 5 years. The third and most serious is I can terminate you from community control and sentence you to prison for a period of up to 36 months and fine you $10,000. Now, you understand all those consequences?
Yes, sir.
And
I'm still guilty.
okay, well, just a second. Has anyone promised you anything or threatened you in any way to get you to do this?
No, sir.
And, all right. Then do you admit to the allegations as alleged in the complaint?
Yes, sir.
All right. Anything from the state regarding disposition?
Thank you, Your Honor. Mr. Balzer from the probation office does have a bed date available for Leona for Star effective March the 23rd, 2023. I think maybe that going that direction might work. I'm not sure. Would note that there, other than what's outlined in this probation violation, my understanding is that she was going to cite at Paint Valley Mental Health, that they thought or suspected that she might be faking her drug screens there. And when Mr. Balzer was made aware of that, he gave her drug screens and she started failing them. I also would note that, this is only intel, but we have intel that she's still not only actively using, but actively selling methamphetamine. So if the court is inclined to send her to Star, we would ask that she be remanded to the jail until the Star bed date is available.
All right, Mr. Kirk.
Thank you, Your Honor. Would ask court to follow the recommendation of the probation department and grant Star. In speaking with my client, there was obviously a relapse. There's no excuse for it. She made no excuse to me. I think if we could get her to Star and kind of get her thinking in line, that she would then benefit from a substance abuse program after attending Star. So would ask the court to consider that. It is her first felony conviction that she's under right now, as far as I'm aware. And I think Star would be a good place to start to try to hit the reset button here. Thank you.
Ms. Reinhardt, anything you'd like to say?
Yes, sir. I would like to apologize to Drew and you and my whole county because I was a burden to y'all. And Drew did try to give me the chance and asked me one time, he said, you'd rather go to prison than you would to learn. And I told him yes. But then when I went to rehab, I realized there's so much I need to learn.
Well, yeah, you're right about that, because I don't think you learned anything when going to rehab, because you weren't there long enough. And you've shown clearly that you're not committed to sobriety at this point, and that seems to be the issue. And it may be that in order to continue to support your habits, you're engaging in contracting again, which if you get arrested again and convicted, that's definitely not going to be very good for you. But I'm going to give you one last chance, and I'm writing down here, right here. So here's my pen and my paper. I wrote down last chance. This is me circling that, and this is going to go into my file. And so if you get charged again and you come in here and you are found to have committed violations of your community control, there will be a prison sentence. So you need to understand,
Yes, sir.
this is it. Because Mr. Balzer gave you quite a few opportunities before he brought you here to court, which is okay, because I want that to happen. Because a lot of people get the idea, once they have messed up once or twice, that they better do what Mr. Balzer says or they're going to come here to look at me. And he's a lot younger and better looking than I am, and a lot nicer. And a lot more patience, I think. So just understand, this is your last chance. So I'm going to continue on community control. I'm going to require you to be held in custody until a bed is available at Star, and that is March the 23rd, I believe.
Yes.
Yeah, March 23rd. You'll be required to pay the court cost. And I'm going to extend the community control by 6 months. And I'm going to refer you to the drug court docket for consideration of entering into that docket if you successfully complete STAR. Your conditions, successfully complete STAR and aftercare. And then that is a voluntary program. It's not mandatory, but they'll talk to you and see if that's something you might want to use. I think it's in view of what you've done since you've been on paper that is something you ought to give serious consideration to. But again, I don't force people into it because it's voluntary. If you're not committed to it, it's not going to work. And
Is
I
she
can't
eligible for that?
Oh, wait a minute. This is an F3 trafficking, isn't it? Yeah. So she's not. Yeah. It's only F4 and F5 trafficking. So I'll just strike that off there. Thanks for reminding me of that. I forgot it was an F4 or F3. So that's not available. Now, when I say successfully complete STAR, Ms. Reinhardt, that means you must graduate. There's no half measures. You don't get credit for 90% or 95% or 98%. It's 100%. And
Yes, sir.
that or nothing. That or you go to prison. Simple as that.
Can I go on my aftercare when I get out of STAR? Can I go to like GCC or GHH?
Absolutely. That's something you'll have to, yeah, that's possible. Again, it all depends on availability, but that is part of aftercare that they look at STAR. We strongly recommend residential treatment after STAR. STAR addresses mostly criminal thinking and changing your thinking to allow you to deal with your issues. And there are components of treatment, but you'll need further treatment after you get out of STAR, without a doubt. That's why I include aftercare. And if they tell you should go to transitional or residential treatment, then by all means, that is what you should do.
Okay.
All right. Anything further from council?
No, Your Honor.
All right. We'll put on an entry. You'll be taking the STAR then on the 23rd. Thank you.
Can I get up?
All right, we're on the record. All right, there are two cases here involving the same defendant, State of Ohio versus Autumn Dawn Corlonis. Case number 19 CR 221, 20 CR 041. The state is being represented by Special Assistant Prosecutor Michelle Harris, Assistant Prosecutor in Brown County. The defendant's being represented by William Armentrout. They are appearing from their offices by Zoom. And you, Autumn Corlonis, appearing there from the jail?
Yes, sir, Your Honor.
All right. Now, Mr. Armentrout, I know we continued this out about a week ago, or maybe a little over a week ago, so you can consult with her. Before we continue, are you and Ms. Corlonis both in agreement this hearing may be conducted remotely using Zoom rather than her appearing in person in the courtroom?
Yes, we are, Your Honor.
You're all right with that, Ms. Corlonis? You waive your presence in the courtroom?
Yes, sir, Your Honor.
All right. Now, Mr. Armentrout, are you prepared to go forward on the hearing, or will there be admissions?
Your Honor, I talked with Autumn both today and yesterday. We went over all of the allegations, both on the November or the January and February filings, and Autumn's prepared to admit to everything alleged, Your Honor.
All right. And I need to looking for the February notification. I know we had a second one filed. Well, I can find everything but the notification. Must be in the other file. Yes, okay, there it is. All right, so Ms. Corlonis, the probation department filed notification in writing on January 27th that alleged that you had violated Rule 2 on 10 occasions. The first count was on 12/29 when you ordered a report to your officer. Second is on January 17 of 23, you failed to report at 8 a.m. as scheduled for community service. You're 39 minutes late. Count 3 on about 1:18, failed to report at 8 a.m. for community service. You were 8 minutes late. Count 4 on about 1:19, you failed to report at 8 a.m. You were 10 minutes late, community service. Count 5 on 1:19:23, you failed to report at 12 p.m. as scheduled, 60 minutes late. Count 6 on or about 1:20:23, you failed to show for community services scheduled. Count 7 on or about 1:24:23, failed to report for community services scheduled. Count 8 on or after 1:24:23, you failed to call in and report as scheduled. Count 9 on or about 1:25:23, you failed to show for community services scheduled. Count 10 on or about 1:26:23, you failed to show for community services scheduled. And then alleged on Rule 7, count 1 on or about 12:15:22, you purchased a medical marijuana card. Count 2 on or about 1:13:23, you failed to call in on the drug testing system. Count 3 on or about 1:19:23, you failed to show for a scheduled drug test. Count 4 on or about 1:21:23, you failed to call in on the drug testing system. Count 5 on or about 1:24:23, you failed to show for a scheduled drug test. Then the 2/8 notification added count 11, that on or about 1:30:23, you failed to show for community service. And it added count 5 to the Rule 7 allegations, count 6, that on or about 2/2/23, you failed a drug test for methamphetamines, amphetamines, and marijuana. And you were informed of those allegations, and Mr. Armentrout was appointed to represent you. Now, Ms. Corlonis, you have a right to have a hearing on these matters, these allegations, in which the state would have to present testimony through witnesses that you have, establishes to the court's satisfaction that you have failed to comply with those conditions. You do have a right to have your attorney cross-examine those witnesses to try to bring out evidence that would help your side of the case. You have a right to present evidence on your own behalf, although you're not required to do so, and it would not be held against you if you did not. Now, in the event that you are found to have violated these conditions, whether we have a hearing and it's proven, or whether you admit to it voluntarily, one of three things can happen. I can terminate your community control, which is most serious, terminate you from drug court, and sentence you to prison. In case number 19 CR 221, that could be for 18 months. Case number 20 CR 41 on count 1, that could be for 36 months. And on count 2, it could be for 18 months. And all of those could be ordered to be served consecutively to each other. So the total would be 54 months possible in 20 CR 41, 18 months in 19 CR 221 for a total possible of 72 months. Plus, there could be fines imposed as well. Now, you understand all the allegations against you?
Yes, sir, Your Honor.
You understand your right to have a hearing on those matters?
Yes, sir, Your Honor.
All right. Has anyone threatened you or promised you anything to get you to waive your right to have a hearing and to admit to these allegations?
No, sir, Your Honor.
All right. Now, I didn't say this in the beginning, but since we're not in the courtroom with you sitting next to your attorney, if you need to talk to him about anything at any time, let me know and I'll put the two of you into a breakout room. So, before we go any further, do you need to talk with Mr. Armentrout anymore?
Not at this time, no. No, sir, Your Honor.
All right. You have any questions about any of the rights I've explained to you or the consequences of your admission?
No, sir.
Okay. Then do you admit to the allegations that were filed on 127 and 28?
No, sir.
You don't admit to them?
Oh, yes, I meant to. I'm sorry.
Okay.
Sorry.
All right, no problem. All right. Anything from the state and or the probation department regarding disposition? Ms. Harris?
Your Honor, just to note for when I was reviewing this case, it does look like there was a substantial amount of restitution ordered on both these cases, of which I believe only $75 was paid over the lifespan of this case. I will note that for the record. And then I spoke with the probation department earlier. It's my understanding that she has already been to STAR, but they are still willing to work with her due to her relapse. And they were recommending, I think, the STAR relapse program for her if they were going to continue her on probation.
All right. Mr. Armentrout?
That's my understanding that the probation has secured a bed for her, I believe, tomorrow. If you look at the probation violations involved here, Your Honor, it's classic. She's still relapsing on a daily basis, it appears to me. She still is in need of help. Speaking with her both yesterday and on Sunday, obviously she would rather not go to prison, would like to take advantage of I guess, one more chance. So we'd ask the court to consider keeping her on probation and send her back to the STAR program.
Ms. Corlonis, anything you would like to say?
Your Honor, I agree with Mr. Armentrout. I agree to stay on probation and continue throughout drug court, and I feel like I need the guidance and the support and the accountability. And that's all I got.
Well, Ms. Corlonis, you know, the wording you just said is intriguing. You said you agreed to stay on community control, and I think therein lies your problem. Your problem is not just drugs. Your problem is your apparent total lack of willingness to do what you're told to do. You talked about accountability, and that's exactly right. You need to be held accountable, and you've been held accountable over and over again. I have been on you for 6 months on drug court, almost every session, to the point where some people probably thought I was picking on you. I know you did, but I kept warning you. You're going the wrong direction. You went through treatment, you stayed in residential treatment, stayed in transitional housing. As soon as you moved back here, your problems began. And they've continued. And you were warned about it. You lied. That's not part of an alibi, but you lied, and it came out in our drug court hearings that you were lying. You were hiding things. You were doing things that you weren't supposed to be doing. You had jobs, you quit the jobs. And then, you know, how many times have I mentioned in drug court hearings, you don't get a medical marijuana card when you're on community control, and then particularly in drug court, and you did it anyway. And then also telling is at our last hearing where I committed you to jail, and you demonstrated what you really are, is a child you're just a spoiled brat who got upset because daddy laid the law down, and you were crying. And that's the reaction I used to get from my kids when they were like 6 or 8 years old. And you just, you know, you've been flagrantly violating the conditions for the last months of drug court. They have, now everybody on your team has told you that. We've heard report after report that you were not doing what they told you to do, what they tried to get you to do. You just wouldn't do any of it. You just wouldn't. There's the problem. It is not the drugs. It is your attitude. And we have worked with you and worked with you and worked with you. And, you know, while the drug court team would be willing to work with you, and they've said they will, I don't think that they expect any different result in the future. I know there will not be any different result in the future because you're just not committed to sobriety. And so we're going to go ahead and terminate you from the program. You know, I'm finding that you're not amenable to community control, and that there is no purpose in continuing you in the drug court program because we are using resources that are not having any benefit to anyone, including you. So it's order of the court in case number 19 CR 221 that your community control be revoked and that you be sentenced to prison for a term of 9 months. You'll be given jail time credit in that case of 146 days, which was from your original date of arrest on October 27, 2021 to 11/8/2021 and 7/31/20 to 8/12/20. I'm sorry, that's wrong. I got the two cases mixed up. Your actual jail time credit in 19 CR 224 is 146 days, which was your original arrest date on 1/7/20. Case number 19 CR 221. Yeah, jail time credit is 146 days, according to the sheriff's certificate. Now, restitution as ordered will still be required to be paid. That stands as part of the original sentencing entry. And that will continue even after you complete your prison term because it's a substantive order and it can't be discharged by bankruptcy. It doesn't get paid off by you serving time, and it'll follow you until it's paid off. You die, whichever occurs first, which I'm afraid at your rate is what will happen. Now, in case number 22 CR 41, on count 1, you're sentenced to a term of 18 months. On count 2, you're sentenced to a term of 24 months, and those sentences are ordered to be served consecutively to each other and consecutively to the sentence in 19 CR 221. Court finds that consecutive sentences are required because, first of all, the case number 20 CR 41 was committed, I believe, after you were indicted, and yes, it was after you were indicted in case number 19 CR 221, but prior to conviction. But while you were awaiting trial, I believe, in that case. Yes. Also, the harm for these various instances, they were committed as part of two separate, distinct courses of conduct, and one single sentence will not adequately reflect the harm to the various victims in the cases. And the sentence that's being imposed are a total of 35 months out of a possible 72, so it's significantly less than the maximum. And the court finds that your history of criminal conduct is such that it's necessary for the protection of the public that consecutive sentences be imposed. In case number 20 CR 41, your jail time credit is 24 days. And you still have a restitution order there that will still stand as well from the count 2. Now, upon completion of the sentence, Ms. Corlonis, it is mandatory that you be put on community control on count 1 for a, let's see, I think it's, Ms. Harris helped me here, but I'm thinking PRC changed, it's 18 months to 3 years on a F3, isn't it? On PRC?
Judge, I would defer to defense counsel because I'm not sure off the top of my head either.
Uh-huh.
Sorry.
Okay.
But I'll get the book out.
All right. Mr. Armstrong, you recall, I think that's what it is. It used to be 3 years, and I think it's 18 months to 3 years now, because F4s and 5s are up to 2 years. And although this is an offense of violence, but as before, those were 3 years, and I'm pretty sure now it's 18 months to 3 years. So, anyway, Ms. Corlonis, I'll put it in the final. I'll put it in the final entry, but in any event, I know it's a maximum of 3 years. What that means that once you get done with the prison term, you will be supervised by a parole officer under the conditions set by the parole authority, because they're the ones that do that, not the judge. And if you violate any of those conditions, even though you serve the entire prison term, you can be returned to prison by the APA as a sanction for up to 9 months at a time. But there is, for any single violation, but there is a cap of half of the prison term that's been imposed for all violations. However, if you commit a new felony, then in addition, whatever sentence the judge in that new felony case could impose upon you, that judge could also sentence you to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the new sentence. You're also ordered to pay the court costs in this case, which judgment granted and execution is ordered. And if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you could do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. And I just noticed my math was bad, which is not surprising. The sentence in 19 CR 221 is 9 months, and total sentence in 20 CR 41 is 24 months, and so the total sentence is 33 months. I think I may have referred to it as 35 earlier. But in any event, That's the total sentence. All right. And Mr. Curlinis, I also want to tell you that you will serve the entire sentence. I don't grant judicial release, no matter what they tell you at the institution. They'll tell you to file one. In fact, I think they give them out in the welcome packet. But you know, the court doesn't grant doesn't grant judicial release to defendants who have been on community control for 2 years and had chance after chance after chance and have not made it. You know, you've not made it. There's no reason to believe you will in the future. So I don't waste anybody's time, including the defendants, in delaying the inevitable and granting judicial release to people who have, in the absence of very extenuating circumstances. And there are none here, I can assure you. All right.
Right.
Now, is there anything further from council?
No, Your Honor.
No, Your Honor.
All right, you'll be conveyed to, held in custody and the sheriff until you're conveyed to the institution. Thank you.
What the fuck's going on?
We're not gonna do that.
Oh, I didn't know he was on.
Yeah, he's still in it.